Welcome to Ground Rules, employment law over your coffee break. My name's Pam Howland, and I'm here today with Jennifer Walrath and Doug Plass, and we're here today talking about retaliation claims and the role those play in the workplace. So that's a big topic. As we were gearing up for today, I think we can all agree we kind of like that topic because we deal with these claims in a lot of contexts in a lot of different settings. And it's very important that you, as an employer, as a leader, as a supervisor, HR professional, that you know the basics when it comes to the law of retaliation and you're taking steps to make sure you've done everything you can to avoid a claim that could come in the door, related to retaliation. So the EEOC, the Equal Employment Opportunity Commission, which I'm sure you know by now, but it's the federal agency that enforces our federal employment law anti-discrimination statutes. They keep track of how many retaliation claims they're seeing in any given year. And in 2024, there were a total, when you look at all discrimination claims, of 88,531 discrimination charges made to the EEOC. And of those, how many do you think were retaliation? If you guessed 38%, which is about 33,000, then you were right, because that's how many. So I'm actually a little surprised, I guess, that number is as low as it is, because whenever we have a complaint filed in court, there's almost always a retaliation component with it. So we see these all the time, and we're going to give you a little more info on the different types of facts that a retaliation claim could be based on and the big buckets of retaliation complaints that we see. So I'm going to turn it over to Jen and Doug to talk to you a little bit about some common types of retaliation claims we see, just to give you a flavor of what those look like. So Jen, kind of tell us a little bit about one type of retaliation claim that you see in your practice.
Yeah, well, I was gonna say, I think a lot of retaliation claims follow a general framework, and that is that an employee engaged in what we refer to as some kind of protected activity. And then there was some kind of adverse action taken against that employee, and there's this causal connection between the two things. And one type of claim that we see that kind of follows that pattern would be claims of retaliation under Title VII. So if you remember from past podcasts, Title VII prohibits discrimination and other unlawful acts based on someone's protected class status, right? So based on their sex, based on their race, national origin, religion. And so here, retaliation would be that someone has engaged in a protected activity that ties in to one of the protected class statuses and has suffered an adverse action as a result. For example, someone has reported sexual harassment, potentially of themselves or of a coworker or someone else in the workplace, and a month or two later finds that they have been denied a raise, or they were up for a promotion and didn't get it. It may not be that it was retaliatory, but because of the close time proximity of those two things, that individual may well have a claim that that action against them was retaliatory for reporting the harassment. It also could be things like reporting pay disparities, particularly if it's based right on sex or something else. Maybe also you asked for an accommodation, like a religious accommodation, and then maybe the employee later on feels like they've been retaliated against because they requested that accommodation. So those are the kinds of claims that we sometimes see under Title VII. And I would say, as Pam mentioned earlier, frequently whenever we see a harassment or discrimination claim that we're handling, there's often a retaliation claim that accompanies it where the person says the adverse action was also in retaliation for some protected activity they engaged in.
Yeah, good point. That protected activity concept is the common thread that runs through all the different types of retaliation claim. That's really what retaliation is all about. So I engaged in some type of protected activity, and then somebody punished me for it, basically. So Doug, how about you? Like, what's another type of retaliation that you see?
So, something that's become a pretty big part of my practice is we have a statute here in Idaho called the Idaho Protection of Public Employees Act. And this is an anti retaliation statute. And basically, what it says is that if a public employee, so that's an employee of the state or political subdivision or some sort of taxing district or something like that, um, reports a violation of law or some sort of waste occurring. So this would be, waste of public funds. If they make this report and then they suffer an adverse action, kind of like Jennifer talked about, then and there is some sort of causal connection between that protected activity, which is reporting waste or even taking part in an investigation having to do with waste or violations of law, then they are protected from retaliation if they can show that the protected activity and the adverse action are causally connected. So and these claims are really interesting, and I think very popular with the plaintiffs bar, in part because they're really difficult to disprove at the onset, right? So these cases can get far along before you can actually, prove that this causation did not occur. Another thing that I'd like to point out is that in terms of this protected activity, there's always this good faith element, right? So we start talking about this, somebody might be thinking, aha, all I have to do is report that something happened and that'll protect my job. That's not the way it works, right? You have to actually make this report in good faith and not for the purpose of protecting your job or ginning up a retaliation claim in the future.
Yeah. So as Jennifer was saying, under our big anti-discrimination statutes, it could be Title VII or it could be the Idaho Human Rights Act. If somebody tries to bring a complaint under that, that could be protected activity for private or public employers. And then, as Doug was saying, we've got this specific state law here in Idaho that relates to public employees and them engaging in some type of protected act. And as Doug was saying, our Idaho state statute, and I do think most states have a statute like that, but our Idaho state statute, which some people would refer to as a whistleblower statute, is broad, and it has protections in it that say if you participate in an investigation, that alone might be enough to get protection under that act. So we do see a lot of litigation under our Idaho state statute, the IPPEA. And I don't know if you guys remember or not, but like Doug said, the plaintiff's bar does like bringing claims as retaliation. And our first ever guest, Emily McMaster, was talking about that. Like you're gonna see a preference for attorneys on the plaintiff side bringing retaliation claims because, like Doug said, in some ways they are harder for the defense bar to defend against. So there's also another type of retaliation claim that we see here in Idaho, and I refer to that one as wrongful termination in violation of public policy. This type of cause of action would apply to private employers because, again, they don't have that statute that Doug was just talking about that protects the public employers already. But it basically says, look, you can't fire someone for engaging in a protected act, among other things. That would violate public policy. So sometimes we see retaliation claims brought under that just what we call common law theory, it's kind of a big catch-all. Wrongful termination in violation of public policy. It's possible you could see a retaliation claim called that. I've seen it as somebody brings a safety concern forward. It could be, hey, my employer's violating OSHA, and then suddenly that employee's terminated. That could be the type of thing you see under a wrongful termination in violation of public policy claim. You could see like maybe a wage and hour claim brought under that. And, that doesn't mean there aren't statutes that would specifically allow employees to bring it a different way, but you could see it looped into this general catch-all provision. I've seen employees raise issues related to that for things like ethics violations, maybe my employer's violating a grant provision. I don't know that there's established Idaho case law on that, but I have seen claims like that raised. So those are all the different types of big buckets of retaliation claims. That doesn't mean there aren't more, but those would be the ones that we see most frequently crossing our desk here. So let's talk a little bit about one issue that employers have when someone comes forward with a claim of retaliation, which is this practical realities of what does an employer do if somebody comes forward with a complaint and the employer feels like there's risk with keeping the employer there. I mean, that really is kind of the rub that employers face when they're on one hand trying to comply with the law, but on the other, worried about whether or not continued employment is going to create some kind of risk on a claim.
Yeah, that's a big problem. I mean, think about it. So somebody brings a complaint against you, your immediate reaction is not going to be, gosh, I want to make sure I protect their job, right? Your reaction is going to be, oh my gosh, this is going to be expensive for me, and what are they going to do next? And and employers need to try to silo that to the degree that they can. And from the employee's perspective, they've just, gotten to the point where they're ready to make a complaint about something, and all of a sudden everything that happens to them is seen through the lens of that. So once a complaint is raised, everybody's thinking about retaliation, and once you start thinking about and looking for retaliation, then it starts to pop up everywhere. So you have to make sure that you take steps to be kind of careful and methodical with your employees and base your decisions on appropriate bases, on their work performance, on their conduct in the workplace, and not on whether or not they've engaged in this sort of protected activity.
Yeah, I agree. I actually had written down before we started the podcast that I think one of the hardest things for employers is navigating an employee who has made a report, who then remains employed, and there's just this tension in the workplace. And I agree with Doug. It is a difficult thing, right? It's easy for us to sit here and say, look, if you've reported something as an employee, I like to say you're not bomb-proof, right? It's not like you can go and then do anything you want and get away with murder, essentially, right? I mean, you still have to do your job. You still have to follow the policies. You still have to do what's expected of you as an employee. At the same time, as an employer, right, you don't suddenly get to get more persnickety about their performance, right? You do have to still follow the same processes and procedures and protocols as you would with any other employee. And it's very easy to say that, but I think in the devil in the details on a day-to-day basis, that is difficult to do. So just being mindful, I think probably for everyone concerned, to focus on policy, focus on procedure. Don't do things differently than you would do for any other employee. And, in some ways, time heals all wounds, all things, right? As time passes from the time when an initial complaint was made, typically it will be less and less likely that anything that happens is attributable to that complaint.
So that's a good segue. I mean, I think focusing on policies and procedures that could be the big takeaway here for employers is you need to make sure you've got the right safeguards in place so that if an issue like this comes up, you've got the right policies and are really maneuvering through it in a way that gives you the most options and a solid basis for a defense if someone were to claim that you were retaliating against them. As you guys were talking, that's what came to my mind, is thinking about if you're an employer, somebody brings a complaint, if you jump to conclusions without investigating it, you might think, well, that's false. This is clearly a setup, right? That's why so important to make sure you've got a good investigation protocol so you're not acting on assumptions or gut reactions, but you're actually, going to base your decision and have your workplace being governed by the real facts and not fear or assumptions. So let's talk about some of these things that employers can do to make sure they've got the right safeguards in place.
So we say this over and over again, but get a good employee handbook. That's the first place to start. So generally, most employers that have any sort of handbook will have equal employment opportunity policies, and these generally have a good anti-retaliation provision in them. Another thing we see is kind of more broad anti-retaliation policies that employers may want to consider, which is basically, if you report anything to me, we're not going to retaliate against you for doing that. So make sure that you have kind of well-developed policies in your handbook, and more importantly, make sure that you follow them. Make sure that you read them, that that that's the case. If you're investigating something that happened in the workplace, tell the people that you're investigating, hey, you can't be retaliated against for sharing this with me. Makes them more open, and it puts you on notice that, hey, I need to keep this separate from my conclusions about their conduct and their performance. Those are different things.
And your supervisors need to know those policies too, right? Like, because if somebody gets a complaint to them, they better know what to do. So, one last thing on that. I see a lot of handbook policies that I don't think comply with the EEOC recommendations, which have, if you were to look at the EEOC guidance on what your anti-harassment, anti-discrimination policy should have, it's pretty robust. So if you have a tiny little anti-harassment, anti-discrimination policy, it may well not have the type of stuff you need for complaint procedures, anti-retaliation, all that.
And I was going to add to the pile in terms of tools that it's helpful to have. We've talked about this before as well, but things like job descriptions, right? If you have an employee who made a report and maybe it's 2 months before a regular review process, it's going to be very helpful if you have a job description that really sets out their functions. So that's a tool that you can refer to when you're conducting and doing the review, right? So if you do have to be in a position where you're saying this was poorly performed and it's an issue, you can point to where that's required and what the expectation says. That's not to say the employee won't feel like something about that is retaliatory, but as the employer, that's a very helpful thing and a good tool to say, no, it's legitimate. This is a legitimate issue, legitimate concern. And piggybacked with that, I would say, and again, we've talked about this before, not the sexiest subject, as Pam often says, but documentation, right? If you were in the regular habit and practice of documenting, both good and bad things about people in your workforce, if you have a history of documentation that shows something was an issue, perhaps even prior to the report and after the report, that's going to be something that shows that whatever the concern is legitimate. And if you don't have that, it's going to be a lot easier for the employee to both feel and be able to argue that what you were doing in terms of giving them a negative performance review or perhaps affecting pay decisions, for example, was retaliatory.
And make sure you've got someone internally who knows how to investigate, right? And that you've got a complaint protocol that kind of spells out generally what an investigation might look like or how to trigger one. But it's so important if you're an employer that you've got some plan in place as to how you're going to handle a complaint. Are you going to investigate it internally? If so, is somebody internally trained? Because what you really don't want to do is fly by the seat of your pants, have a complaint come in, assign it to someone who doesn't know how to investigate or what an investigative report needs to look like. Like, that's another important thing to think about. Well, I'm sure we're going to have our own podcast about investigations because they're so important and there's a lot of nuances to them. So stay tuned for that at some future point. But for employers, make sure you've got somebody who knows about investigations or gets the training they need.
And Pam, that made me think about, what happens when you have a bad investigation? Well, in terms of retaliation, well, what happens is the person who made the report, it gets back to them through their coworkers, and their coworkers start to do and say things to them that later gets attributed to the employer, right? So this is the retaliation circle that the coworkers do stuff, and then the employer doesn't do anything about it, and all of a sudden you have a retaliation claim. So yeah, investigations, do it right and take it seriously. Absolutely.
Yep. And then the last thing I would add on that is just another thing for employers to be thinking about, which kind of goes hand in hand with what Doug was just saying. This gossip or, not making sure you've got the right culture, the right level of professionalism, the right level of respect in your workplace. So important when it comes to, reducing the odds of having a retaliation complaint brought, that you've got this culture where leaders, supervisors, pretty much everybody in that workplace is dealing with each other with a level of respect, professionalism, and not engaging in bad behavior that has a tendency to foster retaliation claims like this. And I can give you an example of that. So we got asked to do an investigation for a client a couple of years ago. Somebody had brought a retaliation complaint to legal. And when we started investigating that complaint, what became apparent was that some high level leaders in the organization were bullies, for lack of a different word. They were good performers, business developers, made the company a lot of money, but they weren't treating the people who were in the trenches working on a day to day basis very well. They were degrading, demeaning, had their favorites, and would say things if somebody was vocal about an opposition or maybe had a counterpoint to something that was being discussed. Leaders would say things like, this is kind of my way or the highway attitude. And when you have people treating others that way, it makes people feel like their jobs are threatened. Like, hey, maybe I brought this issue forward and your response was to call me out in front of a room full of people and make it sound like my job's now in jeopardy for doing that. So, this concept of respect and professionalism, it again is a common thread that runs through all of this. And if you don't have that in place, that certainly opens you up for potential claims of retaliation under any one of these categories. So, that's kind of the broad overview. Jen, Doug, anybody else have anything else to add on retaliation?
I was just going to put another plug in that the, issues Pam was just talking about, a lot of that does swing back around to your supervisors, right? Your supervisors largely have a lot of control over dynamics in the workplace. They're also the people who are potentially going to be making decisions that an employee might perceive as retaliatory. So all to say, just I get another plug, I guess, for like making sure your supervisors are knowledgeable enough about this to recognize when it's an issue, when it could be an issue, and when they're making decisions that are impacting employees to ensure they've been thoughtful about it and just making sure there are good, legitimate reasons for what's happening.
Yeah, and what Pam was just talking about, if they're, culture starts at the top, right? And if you have a culture, a retaliatory culture at all, it's going to be problems. It's going to make claims down the line. So your leaders need to take this stuff seriously. Absolutely.
Yep. So what do you do if you're listening to this and you're thinking, well, how do I get my supervisors trained? And how do we know how to conduct investigations? We have got solutions for you because we have a half-day supervisor training coming up fast. I mean, it's on June 18th. And then we have a workplace investigation training coming up several months after that. Those are great ways to get some better tools and training in place. And then don't forget about our Law for Leaders book. We actually have 2 chapters in that book that relate actually more than that. We have one on documentation that pretty much relates to every issue we're ever going to talk about. So keep that in mind. But we have a chapter on what to do if somebody brings a complaint, and we have a chapter that specifically talks about retaliation. So that's another very easy way for you to get training. We have our Law for Leaders virtual content and in-person training. There are tools out there if you want to get some safeguards and training and protocols and procedures in place. We don't want to hear anybody saying there aren't options out there, because if you're in Idaho, we've got a bunch of options, and they're easy and makes sense to do it. Much easier to do that than to be sitting in our office working with us to defend a lawsuit against you. So that's it today. Thank you for joining us on Ground Rules, and we'll see you next time.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.